Hello, hi everybody. I'm Sarah Harris. I'm the managing editor of the Journal of IP Law and Practice, or JIPLP, and I'm very proud to welcome you to our first JIPLP webinar for 2021. And we have a superb panel of speakers who are authors of the EU Enforcement Case Law Roundup, which is an annual survey of Court of Justice and selected national case law. And the article is currently freely available on the JIPLP website, whether or not you're a subscriber, so do take advantage of that. And there's a link in the chat box. On that note, we'll be posting all relevant links in the chat box for you, and thank you to Nora from IPvocate for organising that. So today's webinar is in two parts. First, a brief update on the current landscape, followed by some analysis of substantive matters and key cases. We'll aim to keep the main session to about an hour, and there'll be time afterwards for questions, so do put those in the chat box. So the speakers. First, we have Willem Leppink, who heads Plume, the IP team at Plume in the Netherlands. He's an expert in trademark, copyright and advertising law. Willem's an active member of several international organisations, including Marks. He's a WIPO domain name panellist and expert, and we'll hear more about that shortly. And happily, we benefit from Willem's expertise on the JIPLP editorial board, which he joined at the very beginning. Second, we have Carina Gommers, a partner at Wigan, where she recently joined their new Brussels office. Carina's practice covers IP litigation and trademark portfolio management. She has extensive experience of customs seizures of counterfeit goods. Carina's second Vice President of ECTA and also a prolific writer, and thankfully a long-standing member of the JIPLP editorial board. And finally, Marius Schneider, all the way from Mauritius, as founder and head of IPvocate, a boutique IP firm with practices in Brussels and Mauritius. Marius is an IP attorney of more than 20 years standing. He has wide-ranging experience of IP enforcement in Europe and Africa. He's the author of several OUP books, a loyal supporter of JIPLP, and has been a member of the editorial board and consulting editor since 2015. So that's our super panel of speakers. So now I'll turn to Willem, WIPO domain names. Willem. Willem, you're muted.
Yes, yeah, absolutely. Thank you very much, Sarah, for the kind introduction, and really happy to speak to you all. Wanted to touch a little bit on what is happening at WIPO. I spoke about that in last year's session. I think it is quite special that last year in 2020. WIPO passed the 50,000 cases milestones of UDRP cases. I think it really shows that there is room in this world for ADR also to solve IP issues. As you may have seen, WIPO and the Arbitration and Mediation Center has also been in the news, also as a possible solution for dealing with problems on platforms. And especially there also with the international nature, I think that is also welcomed by many people. What you will see, and that's also interesting, ever since the beginning of the current pandemic, WIPO has experienced 11 out of the 12 busiest periods in terms of UDRP filings ever since they got started. I always sort of still have to question whether that is just a, let's say, a COVID impact or still the impact of the GDPR. As you all know, the GDPR had a strong influence on information that was to be obtained in relation to the who is. So if you want to complain about a certain domain name, yeah, there's often not an opportunity to send out a cease and desist letter first, but you need to file the complaint in order to find out actually who the registrant of the domain name is. On that topic, I think it is very important that there's still a lot of work being done within ICANN on that topic of the GDPR and the who is. So they're still working on it, and also the UDRP is under review, which will take place probably this year. For WIPO, I think it's there are lots of things happening. They are currently still adding on let's especially country code domains to their system. .ac, .sh, and .io were added. Those were for Ascension, St. Helena, and for the British territories in the Indian Ocean. But as you can imagine, .ac is really nice if you're in the academic world. .sh, except for that it is nice for Sarah Harris as a domain name. It's of course very nice if you want to shorten your domain name and you have something that ends on at .sh. You can do swoosh. There you then do swoo.sh. And I already found out that, of course, the most famous inhabitant of St. Helena, Napoleon, there is already someone who registered Napoleon.sh. And of course, .io is interesting for people that are in the computer business, because IO means input output. Also, there were third-level domain names added to the system under the Ukrainian domain name UA. And what I think is the same happened to Saudi Arabia. That's also the .sa domain name dispute resolution is also now with WIPO and can be done not only in English but also in Arabic. And what is still interesting is that both at WIPO and also at the Czech Arbitration Court, it is still possible to complain about .eu domain names with a large subsidy. So as most of you will know that for example, under the UDRP, a complaint will cost $1,500. For the .eu domain names at the moment, it's only €100 as a filing fee, because that is heavily subsidized by EURIT, the organization, the registrar for the .eu domain name. So that's the quick update as regards domain names. And like with all the following topics, please feel free to share any questions you have in the chat.
Thank you, Willem. That was great. And I might just register the .sh. Now we're going to change the subject completely and move to Carina, who's going to talk about current design reform. Carina.
Yes, thank you, Sarah, and thank you indeed for the kind introduction earlier. It's good to be here and good to see some of you at least this afternoon. What I wanted to do is indeed touch upon the current design reform in the European Union. We've had this design reform looming above our heads since we've seen in the last years that the EU legislator really has an important goal to reform all kinds of IP rights, which renders our life very interesting. First we had the trademark package, then we had the copyright package, a lot of changes, and now we're on to designs. And I think it's a logical step also to tackle these design rights. I think it's also long overdue and long due, because if we look back at its legislation from decades ago, the first version of the directive dates back to 1998 already. The first regulation dates back to 2002. So indeed, there was room for improvement, I think. We had a first consultation already in 2018 on the design legislation. I think there has been a lot of backlog also now due to the COVID pandemic, and we're still in the phase of the consultation, whereas now we're in the second phase of the consultation. So first we had this first part in 2018, and then we had an assessment report which shows that indeed, all in all, we can say that the design legislation in the European Union, that it works well, that we've had this harmonization, that had added value. It was positive, that harmonization effort, but still we needed an update and an upgrade of the system, which is also, of course, still on the drawing table is the spare parts issues. And of course, within the European Union, that is a very difficult debate, because some member states have some interests and the other have the exact opposite interest. So we'll see whether this will actually be tackled in this reform, or whether we will have something separate still for the spare parts. So that was part already of the first consultation, and now they've launched, so the Commission has launched the second consultation. where we can submit responses until the end of July. And in that part, it's not a really new general consultation, so they really focus on some specific issues. For instance, they focus on specific different design categories that they would want to introduce, for instance, on graphical user interfaces. They also specifically focus on limitations, and it's very interesting to see that the Commission thinks that they can incorporate limitations from the other type of IP rights into the design laws. And I think in general, that can be a good thing, but also we need to be careful because of course, every IP right has its own purpose, has its own ecosystem. And I don't think that necessarily all these limitations fit in the different IP rights. So you have the private use exception already in design law, and you also have that in copyright law. And now they think of more streamlining that. But it also has issues because of the 3D printing, for instance, in design law, we may have to have different type of private use exceptions in that respect. Another thing that they're looking at is to introduce administrative proceedings. That comes from the trademark reform. They've seen that the offices can handle these administrative revocation proceedings. So now they would also want to introduce those in design law. We'll have to see how that will be welcomed or not, and which delay, because for the trademark package, we had a long delay of 7 years. Are we looking at that same delay, or can it now be shortened because of this previous experience in the trademark package? And then, of course, we have another provision that will be included, and that's the goods in transit provision in design law. And that's also inspired from what we've had in the trademark package. And that, of course, I think is a very good provision to also include in the design law next to the trademark law. And I see Marius nodding, so I know he's already in agreement with me. But that is all I wanted to say about the design law.
Thank you, Carina. That was great. So now, Marius, you're going to talk about goods in transit.
Exactly, the evergreener topic, if I may call it like that, the subject of counterfeit goods in transit in the EU. You will all remember there has been a lot of debate prior and then culminating in the Nokia and the Philips decisions of the Court of Justice of the European Union. After that, we had a legal reform, the trademark package that Carina just mentioned. And that was surprisingly right-holder friendly. We were all, I think, pleasantly surprised with these new provisions that are in effect as far as EU trademarks are concerned since 2016, as far as national trademarks are concerned since the directive has been transposed. So it should be actually effective in all EU member states now. What does the law now provide? Well, the law provides that trademark proprietors can prevent third parties from bringing in the course of trade in the EU or a member state without being released for free circulation there, goods coming from third countries and bearing without authorization a trademark which is identical or essentially identical with the trademark registered in respect of these goods. So what is possible, to summarize it in a nutshell, trademark owners can prevent the transit of counterfeit goods in the sense of the TRIPS agreement, so identical or quasi-identical marks. And this applies not only to counterfeit goods in transit, but also in other customs situations, such as transshipment, warehousing, free zones, temporary storage, inward proceeding, temporary admission, and the like, and irrespectively of the fact whether these goods are actually intended to be placed on the market in the EU or in one of the member states. So, quite a broad possibility to take action. There is, of course, I would like to remind here that there is a safeguard clause, because we have to make the necessary balance between free flow of goods and free trade and trademark enforcement. And so there is a reversal of the burden of proof, which is provided in the regulation. And this applies when the declarant or holder of the goods is able to prove that the trademark proprietor is not entitled to prohibit the placing of the detained goods on the market in the country of final destination. And I have expected a lot of cases around this, to be honest, and I haven't seen them. And I don't think that there is a lot of case law in the EU on this subject of transit, not a lot of disputes, contrary to what was the case before. I would have also expected, you know, as a bit of an African lawyer, that these traffickers come up with destinations for goods where it's impossible or close to impossible to register a trademark, for example, Somaliland. But actually that hasn't happened. We had a few cases of goods in transit, and in all of them, the owner of the goods has actually abandoned them voluntarily for destruction. Why is the subject so important? That's maybe my closing word. When you look at the statistics, and the last statistics that I found were from 2017, they do indicate that 1% of the detention cases in the EU relate to goods in transit, and by the number of goods, that is 11% of the articles seized at EU borders. So, you know, it's quite a substantial chunk of counterfeit goods that are concerned by this provision. So it's important, and it's good that it will come, as Carina just explained, also in designs. So that's a great step. Well, thank you very much.
Thank you all. Now that was the first part, so if anyone has questions about that part, please do put them in the chat box and we'll come back to them at the end. Now, the second part of today's webinar, I'm going to ask Willem to begin here, and Willem is going to talk about the European interplay between trademark exhaustion and referential use. Willem.
Yeah. Okay, thank you again, Sarah. And I think when we prepared for all of this, and also when reviewing all the cases for the overview that we have published in JIPLP, it became clear that very recently there were not that many decisions on the enforcement of trademarks in at the CJEU level. So I think it's interesting to look ahead from where are we going to, what decisions will be coming. And of course there is, and that's separate from, of course, enforcement. In trademark law, there is a lot that was already said in the Skykick and the monopoly cases. So bad faith is a big issue, but I'm also expecting quite a lot of decisions from the CJEU in relation to, let's say, what I would call the limits to what the EU trademark owners' rights are. And like I said, it is a sort of interplay often between trademark exhaustion and referential use. And but before touching on that, and I know that we have a group from all over the world, people from the UK, people from Europe, but also from far away. I think it's good to bring you up to speed on exhaustion in general. And as you will know, different from, for example, the doctrine of first use, there is for trademark owners quite a strong right in terms of exhaustion to oppose the resale of goods that were not placed by the trademark owner on the market in the European Union. Actually, the European Economic Area is a little bit bigger. And at this point in time, following the Brexit, and the the UK not being part of the EU anymore, we have quite a funny, what I would call asymmetrical situation. The goods that have been placed on the market in the European Union can freely flow into the United Kingdom, but not the other way around. So if you, as a trademark owner, have placed the goods for the first time in the UK on the market, they can still be stopped when coming into the European Union. There is some logic to that, but it is a temporary situation, and the UK is now via the Intellectual Property Office doing a consultation on that topic. From where should the UK be going? What is the future regime? And we will be sharing the links to that. And the discussion in the UK is, should it be national exhaustion? Should it be international exhaustion? Basically, everything from all over the world can come in. Or shall we maintain the current status quo? Of course, the ideal situation would be that let's say to maintain that European Union system that there was pre-Brexit. But of course, that's almost sort of impossible, because it would force the UK to have an arrangement similar to, let's say, Norway and Iceland, and that's not going to be something that is going to be achieved. And they are also talking about sort of mixed exhaustion, that there would just be exhaustion for particular goods. And it is all quite complicated. I've understood that that national exhaustion is not the plan, because in the end that will be bad for consumers. I personally expect that international exhaustion is not going to be accepted, because then also British companies will have a real hard time sort of controlling the market. So it probably will be something that there already is, but there's room for consultation. But switching back to the main topic of in particular advertising for exhausted products and referential use, and that is something that's going on in the online and offline world. And these are all kinds of questions. Sort of, when is it? How much use can you make as a trader of the brands you're selling? How much logos can you use when you're doing that? And in the old days, there were also questions, let's say, and we were worried about, could a private label manufacturer of vacuum bags, could they sort of, how can they indicate that those vacuum bags, vacuum cleaner bags, that they would fit into a certain vacuum cleaner? And now these days, of course, you see that it is way broader, and you can think about sort of mobile phone accessories that are suitable for a certain phone brand. A third party produces chargers for a Samsung or an iPhone, but the problem is that you often see that they are then still called a Samsung charger or an iPhone charger, and maybe the manufacturer doesn't do it, but maybe the reseller on Amazon will do that. But also think about ice cream that people are selling and in which they have processed M&Ms or Nutella as an ingredient. And the Internet of Things makes this also much bigger, because it does not only connect the different devices, it will also connect the brands. It will say, my iPhone will work with this and this brand. And this story is actually all about sort of the limits to the use of someone else's trademark. And the interesting bit is that more than 20 years ago already, the CJEU gave its landmark decision in a case which was, I think, very often not completely understood by everyone, the BMW DNIC case. And actually there the CJEU took quite a holistic approach, because it's about two different topics. It is about the topic whether someone who is selling exhausted goods, secondhand BMWs, is allowed to say, I'm specialized in selling secondhand BMWs. And on the other hand, that same garage was saying, I'm also specialized in repairing those. So they were offering services that related to those products. And that was quite a difficult challenge for the CJEU, because they were saying, hey, you can advertise for these that you are selling secondhand BMWs, and you can say that you're a specialist, but there are limits. That was one thing. And at the same time, they were saying, okay, if you are offering repair services for BMW, you are not doing repair service under the BMW brand. No, you're saying I'm doing repair services under my own name, but they're designated at BMWs. So it is referential trademark use, like, for instance, those vacuum cleaner bags I talked about. And in the end, they said the limit that is there is that you're not allowed to make a commercial connection. And that's where it all came together. And later on, we had from the CJEU, we had the Gillette case. And in the Gillette case, this was about sort of replacement razor blades on a holder that, for example, was produced by Gillette. And there the CJEU said this is all important. Consumers need to know also as part of the competition that that one product fits with another product, but they can only do that where it's necessary. And then something strange happened. We had a big trademark reform in the European Union called the trademark package. And then they changed actually the article on referential use. And where it in the old days just said that it is only allowed where it's necessary to indicate the intended purpose, they have expanded it. They have now said where it's that you can use someone else's trademark where you want to identify or refer to the goods or services as that of the proprietor of that trademark, and then they give the example of where it's necessary to indicate the intended purpose. And it's very strange. I'm trying to look into, together with my colleague Arnoud Martens, we have tried to look sort of into the background of all of this. But along the way during this trademark package, it's constantly sort of changed. And we still do not understand what exactly was meant by that addition in the trademark package. What does it mean other than, let's say, to indicate that intended purpose? What does the identifying mean? And we have thought that identifying would mean, for example, identifying as part of, let's say, comparative advertising. But that was not the case because there's a special exception for comparative advertising. So it is all very complicated what it's meant there. And there was a fantastic opportunity before the Dutch Supreme Court in a case called NXP Infineon. And that was about chip card technology. But just think, if you've been in London, think of the Oyster card, that technology, and that was branded by NXP as MyFair. And there was a fantastic opportunity to find out what was meant by the by the European Parliament, and the CJEU could have given there a fantastic interpretation, but it didn't happen. And what happened here in this case was that Infineon wanted to communicate that what it offered was compatible with MyFair. And of course, there was an interesting discussion. How precise does a advertiser need to be if they're claiming compatibility? Do you need to tell all the exceptions? Let's say I have a charger for an iPhone, but it will only fit, let's say, the older iPhones, not the USB-C. It will not have the big old broad plug. So it is, how much do you need to tell? And the Dutch Supreme Court took the view that the trademark package actually didn't change anything, and that this identifying is something else, and that is still, there is necessity needed for indicating the intended purpose. I think it's a missed opportunity that they didn't refer it to the CJEU. And in that same light, and that's interesting, what's happening at this point in time is that very recently, and watch this space, the Finnish Supreme Court referred to the CJEU a matter about two sparkling water makers, manufacturers of those water makers, being MySoda and SodaStream. I think most of you will know that that's a product where you save a lot of plastic bottles because of the fact that you reuse your plastic bottle, and you have a sparkling water maker, which is a carbon dioxide bottle that you put in your machine and then and just water out of your tap, and of course there's a big market for that. And the interesting bit is that those standard carbon dioxide bottles, which are made out of metal, there's on top it is engraved who the original, let's say, party was that brought it onto the market. And what happened in this case, that SodaStream sold bottles with SodaStream engraved on top. And then, of course, people use that and they bring it back and they want a new bottle. And there is common practice that all these bottles are basically shared, in the sense that the SodaStream bottle ends up with MySoda. MySoda refills it, puts a nice jacket around it. Oh, this is a MySoda bottle, but you can still see the engraved mark on top. And the question that pops up here is that a trademark infringement, and what are the limits? And the Finnish Supreme Court was quite quite in doubt about this situation. They were looking at what most Europeans will know as the Bristol-Myers-Squibb criteria, which are the criteria that very much relate to the resale of medicines, of drugs, all over Europe, that have to do that you have different brands and different quantities needed in one country, and you need to repackage sometimes to be able to sell it in another country. But this is about something that has already been used and is then refilled. So it looks a lot more like the Viking Kosen case. But yeah, it's interesting because all parties do it. And actually, I came across a bottle that was put on the market by SodaStream, and it actually had a My Soda engraving on it. So it's the other way around. So it's interesting litigation, and I think, let's say, there is a use to it, that people can use each other's bottles, because it will save environmentally also a lot, because it saves the, let's say, unnecessary traffic in those bottles. So it will be interesting what will happen there. But yeah, let's see that. And but that's my contribution so far.
Thank you, Willem. Now, Carina, before you move on to talking about your cases, do you have anything you'd like to add to what Willem was just saying there?
Yes, I was still in my design mind thinking about the referential use, because of course you have that same issue had it in the Big Ben Nintendo case from the Court of Justice a couple of years ago, where you had Big Ben who had remote controls and accessories for these Y consoles, and they depicted it on their website. And there, of course, you have the citation exception that the court then used or said applied to this situation, and that's more in line with the fair use. Do you think then that for trademarks it should also be more in line with the fair use, now that we have this new provision in the trademark package? And would that then have been a possible outcome in a Court of Justice case when the Hoge Raad would have referred it? Do you think that is the way forward?
No, I think it is. I think it is probably the way forward, and I've looked at that case back then and really realized that it's not in sync. It is very strange. In a certain way, the CJEU is always very much looking at competition law and sort of looking what should be possible. And it's very strange that in the Nintendo case, where they allowed it that you show that you show the Nintendo console, the game console, just to sort of illustrate that it's possible that you can use this accessory in relation to that console, that they allowed that, and certain other use, trademark use, not, where it was just necessary, because you could also say it's only necessary to say works with this console. But why is it done? Because you want to buy something for your kids, and you think, I cannot remember which console they have, but you recognize the image. And that's the interesting bit. I expect that if I read, let's say, what is now in the EU TMR on this specific story about the identifying, I think it was the intention to say it is always fine if it is necessary. That's always fine, because if it's necessary, it's necessary. But it can also be broader, because you could also say, well, it's never necessary to say that you have to say that this phone charger is compatible to Samsung. You could always say it has USB-C. So why is it necessary? But I think it is consumer information. So I think there's some space there.
Yes, I absolutely agree, because I think it's consumer information. And as you say, some consumers are smarter or more tech savvy than others. And you have this general message that you want to get across to the consumer. So it's interesting, and we'll maybe have a question referred then on referential use in the future. Yeah.
Will happen. Very good.
Great, thanks. So Carina, you're going to talk to us about Coty Amazon.
Yes, it's actually just the beginning to get to the Louboutin referrals, because indeed last year all eyes were on the court for this Coty Amazon case. I remember we were all waiting what the court would decide, certainly after the interesting opinion of the Advocate General. And then, spoiler alert, it was quite a disappointment what came out of Luxembourg, I have to admit. But it is an important ruling, and it is important also because the facts of the case and the services that Amazon is providing are important, and I think we still need an answer, and I hope we can get that in the near future. So it's all about whether or not Amazon is liable for trademark infringement with the services it provides currently. So we actually have to go back to the Google and the eBay cases. Since then, we've had this case law on whether there is liability for online intermediary services. But of course, since Google and eBay dates back to 2011, a lot has changed in the digital world. There are new services have broadened, etc. So the old case law is not really apt or up to date in line with what is currently provided. So I think therefore it is indeed important to have a reassessment and a readdressment of that case law. But going back to the facts of the matter at Coty Amazon. So Amazon, of course, everybody knows Amazon. It either sells products on its own platforms or gives the platform, makes it available for third parties to sell their goods on the platform. And then these third parties who sell their goods on the platform, either they just have like a basic service where they put their goods on the platform and they take care of all the rest, or they have what is called, or they participate in this Amazon fulfillment program. And then Amazon really steps in, becomes very active, and renders all kinds of services. They stock the goods, they ship the goods, they help with price setting, they help with advertisements, they even do some after-sales services for the products in question. So it's really a broad program, that fulfillment program. And in the facts of the case, so Coty had identified infringing perfume bottles, Davidoff perfume bottles, on the Amazon platform, offered by a third-party seller, had contacted that third-party seller, and there was a settlement agreement. And then part of that settlement agreement was that Amazon would send all infringing bottles to Coty. And upon arrival of these infringing bottles, Coty realized that there were a lot of bottles that were not originating from the seller where it had agreed the settlement with. So they went back to Amazon and said, well, can you also provide the contact details of this other seller? Because apparently there is still another seller selling these bottles, and we do not have any settlement agreement with them. Amazon refused to do so, and then Coty initiated these proceedings in Germany against Amazon for direct trademark infringement liability. It lost in first instance and upon appeal, and then the case went to the German Supreme Court, to the Bundesgerichtshof, and the Bundesgerichtshof then referred the matter to the Court of Justice. What is a pity is that in its referring decision, the German Federal Court really narrowly defined and described the facts and the services, and referred a very narrow question to the Court of Justice. And I'm just going to read the question because it is important, and I think we're all specialists, of most of us are specialists here. And if you read the question, you can, I think, immediately infer the answer to the question therefrom. So the BGH says, does a person, so Amazon, who on behalf of a third party stores goods which infringe trademark rights without having knowledge of that infringement, stock those goods for the purpose of offering them or putting them on the market, so on behalf of this third party, if it is not that person himself, again, they reiterate that, but rather the third party alone, which intends to offer the goods or put them on the market. I think if you describe the question so narrowly, then the only answer can be no, it is not liable for trademark infringement. And it actually denies all the services that Amazon renders in this fulfillment program. On the other hand, we had the opinion of the Advocate General, and there the Advocate General made two hypotheses. He also went into the narrow question, and there indeed he said there is no liability, but he actually went further and looked at what actually had been done and provided as services, and there indeed inferred that there could be a liability, or there may be a liability set. So the Advocate General opinion is actually more interesting than the judgment. There is on the bright side, there are 4 possible ways still where Amazon could be liable or get an injunction against it, says the Court of Justice. The first reference is to the e-commerce directive and the fact that if you don't have a notice and then take down, then you are liable. So that's the first, but that's not really new. We knew that already. The second possibility is an injunction under the Enforcement Directive for intermediaries without liability. We also knew that. Then the third, of course, you are liable for your own sales. So Amazon's own sales, there it has liability. And then fourth, and specifically for this case important, you have liability when the actual seller cannot be identified. And that is a slight step forward and certainly important for the facts of the case where Amazon did not want to disclose or did not even know itself the identity of the seller. But all in all, not really satisfactory for trademark owners, or as you would say in the world of online ordering, awaiting fulfillment. And it was then to be expected indeed that we would have no questions. Very recently, we've had 2 referrals, one from the courts in Brussels and one from the courts in Luxembourg. Both by Louboutin against Amazon. And there you can see that the questions that now have been referred actually build upon this judgment and go very much into the details of the services Amazon provides. You can read the questions, they are very elaborate. I've tried to summarize them, and I think you have 2 categories. The first category is really about the active role in commercial communication and advertising that Amazon takes upon itself in this fulfillment program. And the second one is more about the shipping and the stocking of the goods. And if you look at the questions more in detail, it's asked whether Amazon is liable when it has this combination of its own offers and those of third-party sellers. So when you cannot really distinguish as a consumer, is this now Amazon who is selling or offering to sell this product or another third-party seller? Whether it is important, whether there's a comprehensive service to third-party sellers, so assistance in preparing advertisements, setting selling prices, stocking goods, shipping them, an active role in advertisement, and really that this advertisement is perceived as forming part of that operator's own commercial communication. So you see a lot of emphasis is on this active role in commercial communication. So those are the first group of questions. And then you have a second group of questions which relate more to when a shipper is liable for trademark infringement. And then it really iterates actually, is the shipper only liable if it has actual knowledge of the infringing sign, because that could be inferred from the previous judgment, which I think is not a valid excuse if whether or not you have actual knowledge. And then if the shipper has informed the final consumer that it will undertake the shipment after it has stocked the goods for that purpose, or if the shipper has previously made an active contribution to the display or the advertisement, or has taken the final consumer's order on the basis of that advertisement. So you see there this communication line, the direct communication line between Amazon and the direct consumer is also important, because effectively, what role is there left for the third-party seller? Actually, Amazon is taking over all kinds of steps in this process. So we'll be waiting for the Court of Justice now to rule on these questions, and hopefully by the time we'll have this webinar next year, we will have some answers.
Thank you, Carina. That was great. Now, when we were talking about this earlier, I think, Marius, you had something to say about the DSA proposal. Do you want to talk a bit about that now?
Yeah, exactly. I did. And as Carina rightly mentioned, the digital world has changed tremendously over the last years. And this is precisely the reason why the European Union has put forward a proposal for a regulation on the single market for digital service, the so-called Digital Service Act. And okay, we cannot go into details because this is a whole legislation on its own. We have to do a seminar on its own on that. But I think it's quite important to be aware of it. The objectives are that they want to strengthen the EU framework regarding liability of online intermediary service providers. The idea is to put in place harmonized rule on conditional exemption from liability. There's going to be specific due diligence obligations that are going to be in place. You have to identify your business contact as such, and all of this should hopefully lead to a higher level of protection for all users. So what is interesting is that this Digital Service Act will not only apply to traders and let's say digital service providers in the EU, but also to all of those that provide services to EU recipients. So one is looking really at the effect, where the service have their effect, and not so much where the service provider is located. And of course, that will allow to regulate also outside of the EU. I don't know. I don't think it's a good idea to go into the details because the time is running up. But Carina, if you want, do you want to explain some of these rules?
No, I don't think indeed we have time, because then we will eat up all of the rest of our webinar with the DSA. I think it's a very important legislation also. But on the other hand, it remains on the injunction type level and the level of the notice and takedown. So effectively, the liability for trademark infringement would go one step further. So I think both are probably needed, but we'll see indeed how both the Court of Justice cases and the DSA moves forward. Yeah.
Thank you both, and thank you for keeping to time, which makes my job a lot easier. And that takes us neatly to the final case. Marius is going to talk to us about, well, originally MBK Rechtsanwälte.
Exactly. So that is quite an interesting case, because it refers to a situation that we all know. You obtain a judgment against an infringer who is ordered by a court to take down certain information from the internet, that can be information on the infringer's own website or on third-party websites. We'll have a look at that. And the infringer doesn't comply with that order. It happens all the time to all of us, I would say. We would rather like not, but voila. And of course, the most frequent situation here is when that is really information on the infringer's website, because sometimes they really don't do the job. They don't amend their website, but sometimes they also forget hidden pages that are not directly accessible and that you can still find. And that is, of course, a clear-cut infringement. Then there are other situations, for example, where reference on a third-party website for which the infringer is directly responsible. I give you an example which makes it all very clear. The person, the infringer, pays or registers with a website to be in an online repertoire. For example, an enhanced telephone book, like in Germany, Das Örtliche, but you have other variations of that. So that's typically a situation where there is direct action by the infringer. And then there is yet another situation, which is reference on a third-party website for which the infringer is not directly responsible. And these are websites who, through their own initiative, put advertisements up on their website. Why would they do that? They do that either as a service to their constituents. So, for example, a city, they could have a city repertoire, if I may say so, where all the lawyers who practice in that city are recorded. Then they just take the information from other sources without even asking the person who has paid for the advertisement, they just take the information and put it on their website. There are other cases where service providers do that to impress other potential clients. So they want to show that they have a nice, neat database and attract other business like that. And it's precisely in these circumstances that the MBK Advocaten ruling has come. That's a case, Nora will display the reference, that's here it is. Okay, so what's the factual background? The German law firm MBK Rechtsanwälte owned a trademark registration for MBK Rechtsanwälte, which was registered for legal services. The defendant law firm, which is now called MK Advocaten, used to operate under the name MBK Rechtsanwälte and the Dutch translation MBK Advocaten. MBK Rechtsanwälte, the owner of the trademark, brought an infringement action and was successful. The regional court in Düsseldorf ruled that the defendant was prohibited from using the MBK name for the provision of legal services, and that a non-compliance with the judgment would result in a fine. The decision was not appealed, became final. And it then came very quickly to light that when one was searching for the keyword MBK Rechtsanwälte on Google, for example, or on another search engine, websites would pop up and they would display still publicity for MBK Advocaten. And one of the websites that popped up is actually a website of the city where MK Advocaten operated and which displayed this advertisement for their legal services. MBK, the owner of the trademark, estimated that this was a breach of the prohibition to sell offer services under the MBK sign, and went back to court to ask for the fine to be applied. The defendant argued that they had only actively registered in the online directory of the local telephone book, enhanced online telephone book, Das Örtliche, and that following the court decision, they had done the needful to withdraw that advertisement. And in the first instance court, the decision, the Court of Düsseldorf, confirmed that there was a violation of the judgment and applied the fine. Why did the German court do that? Because in Germany, you know, our German friends, I say that because I'm myself German, our German friends are a little bit more thorough. So in Germany, it is not sufficient just to withdraw the advertisement that you have actively placed yourself. Under German case law, it is also required that you do a search to see whether others have replicated this advertisement and then make sure that it is also deleted. So you have the active obligation to, you know, search for yourself and then take down. And it's in front of this German case law that the Landgericht Düsseldorf has applied the fine and said, yeah, there was an infringement. Then MK Advocaten appealed the decision. They were not satisfied and actually put a question for preliminary ruling on the compatibility of this German interpretation to the Court of Justice of the European Union. And I will not read it out, you can read it for yourself. The question is, does a person who has actively placed an infringement in advertisement on a specific website use a sign which is identical to the infringing trademark, where the advertisement has been produced or reproduced by a website operator who have not been specifically asked to do so. So this situation when somebody reproduces an advertisement without being asked to do so, is this actually use of a trademark, and hence an infringement. And the Court of Justice of the European Union has ruled in favor of MK Advocaten and said that using in the sense of Article 5.1 of the directive involves active conduct. So it's not if you just, let's say, you have to actively do, because, there's also a question of semantics. Huh? Using or faire usage, nutzen, it really means, that you have to actively be involved. And the court agreed that online advertising of goods and services under a sign which is identical or similar to another person's trademark constitutes use of a sign, but the court also reminded that keyword advertising, where a sign is selected by an advertiser as a keyword in an online referencing service, will constitute use even where the sign does not appear in the advertising itself. That's interflora. But the court agreed that actively, and also the court said that actively ordering an online advertising containing a sign which is identical or similar to another party's trademark constitutes use. In contrast, the court said if decided that such use cannot be found where an advertisement has been reproduced by website operators on their own initiative and in their own name. Okay, and here the court then referred back to its earlier case law in the Daimler matter. And that is quite an interesting reference. And actually, if you read that Daimler matter, you are wondering a little bit why this MBK Advocaten case even made it to the Court of Justice of the European Union, because actually in Daimler, the court had already clarified these matters. That Daimler case related to a authorized Mercedes-Benz distributor in Hungary, who was at the time an authorized Mercedes-Benz distributor. And whilst he was an authorized distributor, this dealer did make a payment to be listed in an online repertoire. The listing was also copied by another replicating website. And when Daimler canceled the authorized dealership, that dealer made efforts to have the listing deleted. But the service providers did not react expediently. And here as well, in a nutshell, the court ruled that the former authorized distributor did not commit an infringement. Now, the Court of Justice of the European Union referred our MBK case back to the Oberlandesgericht in Düsseldorf and asked the court there in Germany to assess the conduct of MK Advocaten, and in particular, whether the operators of the website had placed the advertisement online by order or on behalf of MK Advocaten. If there was no active conduct by MK Advocaten, they would not be liable for an infringement and the fine would not have to be applied. The European Court of Justice, however, reminded that MBK could claim, where appropriate, restitution for financial benefits on the basis of national law, and would have, of course, an action against the website operators itself. And that, in a nutshell, is the decision which you will find in our this year's roundup.
Yeah.
Thank you very much, Marius. We will move on to questions very shortly, but before we do so, I'd just like to ask Willem whether there's anything you'd like to add to what Marius just said.
No, I thought it was just a very interesting what you said, Marius, and also the background of, let's say, the German practice. I think my approach would be that, let's say, the infringer here is not responsible for those acts of those websites that place something on the market. So to me, the decision is very logical, but it's interesting where, let's say, substantive IP law and procedural law comes together, because you can approach it from in two ways. You could say, hey, this is substantive European trademark law, and you need to find an interpretation here. You could also say, hey, this is when you talk about penalties, this is something that depends on what is national law and whether a penalty is forfeited for the situation that you infringe an injunction. So it's I think that could have gone different ways, but I think it's all a fair decision. I think it's good also what the CJAU said about the damage, because if you knowingly, let's say, infringe something and it leads to this ripple in the pond, that it continues, then you might not be responsible through social media when something goes viral, that you cannot say, hey, you have not taken this down from this website, but in the end, because you created that damage, you're still liable for it. So it makes all sense, I think.
Great. Well, thank you all. That was superb, and you crammed an awful lot into exactly an hour. There are a few questions. The first one, I think, is for you, Willem, from Martin, and he says, this is back to the discussion about WIPO domain names. And Martin says, do temporary discounts on fees for .eu domain name complaints also apply when filing a complaint with the Czech Arbitration Court instead of with WIPO?
No, I think that's a fair question. As far as I know, it does. I think that URIT is using both the Czech Arbitration Court and WIPO as dispute resolution providers, and they treat them in an equal way. So give them both a subsidy to go there. So they couldn't distinguish between the two. So it is a way of that if you want to consider filing a .eu, I think it's worth it to do it now.
Thank you, and I hope that answers, well, I'm sure it does answer Martin's question. Next, a question for Marius from Wilfredo. Marius, this is for you. The new regulation applies to both EU trademarks and also national trademarks. That's the
correct,
question.
Yes, that's the case.
And in what sense has the burden of proof been changed?
Yeah, so that's the interesting one, the rebuttal of the burden of proof. So if the owner of the goods can show that he or she can legally sell these goods in the country of final destination, then there is no more infringement. So that's really it. And that's where I have expected that traffickers are, smart, or let's say, try to come up with solutions where they say, well, our goods are destined to Somaliland, as the example I've given, because you can't register a trademark there. And you can almost highly likely sell your products always in Somaliland. So, but I have to say, in practice, and I'm very surprised about that, and I would be curious to hear from Carina and Willem, we haven't had any, tricky legal discussions on this. Most of the cases where we had counterfeit goods in transit, they were abandoned without discussion. Carina, Willem, what?
Yeah, I think in relation to counterfeit goods, I never had that problem, and of course there is still a little bit of uncertainty about the parallel traded goods, the gray goods. Yeah. That's still where you have those issues, and the question whether this exception also applies to parallel trade, that remains a very difficult topic, and it all comes back in the end that everybody speaks about counterfeit goods, but systematically the European trademark system is not so good in defining counterfeits. So that's why they chose that sort of approach of identical or nearly identical. But that's still something for which there's not a good definition of counterfeits in the EU system.
No, and I think also from a Belgian perspective, it's the same. On the other hand, we've seen that there is less intervention by customs of larger shipments because you have the booming of online sales, and of course there it doesn't really play on the same level, the goods in transit issue. But I do not expect going forward that we will have a lot of case law on this grounds, also not in the design law, if and when it will be introduced.
Thank you, great. And there's one final question that for Carina or Marius, perhaps I'll ask you, Carina, from Martin again. Do you believe the proposed DSA will introduce stricter rules for liability of platforms? I believe the DSA was presented as a crystallisation of CJEU case law, which implies it will not bring much change, but rather will confirm current CJEU case law.
Well, I think there is, of course, at the moment, a lot of lobbying going on to really uplift it to a level that it is a higher protection for trademark owners, IP rights holders, but also for consumers. And I think already in the text now, you have at least two tools which really enhance the protection, and that is this know your business client rule, that you will have an obligation for the platforms that they really need to have identification data for the users of their platform. So that is an important step forward, I think. And the other one is also the system of these trusted flaggers, so that some institutions can have this status of a trusted flagger, and then this notice and take down procedure can move forward more efficiently. So that is already in the text, but they're of course still working on the text, so we might have still a more enhanced level of protection going forward.
Yes, and I just maybe to add, there will be rules for large online platforms, so enhanced and stronger rules. So no, I think it's already a good proposal. Can of course be still let's say toughened, and a lot of lobbying, as you say, is going on. But
yes, and it's very broad as well. It's a horizontal type of framework. And today I read a notice that they are also targeting advertisements on Facebook and advertising, personalized advertising, etc., that they want to encompass in this package. So it has opportunities, but we'll see how much is left when it comes to a vote.
Thank you.
So there will be subjects for next year, for sure.
Absolutely, absolutely. And in the meantime, if you haven't already, everyone should read your article, Rounding Up Cases from last year. And I hope that will be followed by a roundup of developments this year too, that should be published early next year. And as I said, the article's currently free, regardless of whether you're a subscriber to the journal. There are also several other roundups available on topics ranging from China trademarks to Africa IP to US copyright. So there's a whole wealth of information, and it's all available for the time being.
And yeah, I would like to also, in the name of us three here, thank you, Sarah, for taking the time to moderate us. We greatly appreciate.
Absolutely.
Yes.
Pleasure.
Thanks a lot.
Pleasure. Thank you. Okay, so on that note, thank you all again, and thank you all for listening and for the questions and engagement. And we'll see you next year, maybe even in person.
Yes, that would be lovely.
Yeah, that would absolutely be